Okay. I see the panel. Was I the only one who got knocked off, or did we all get knocked off?
It seems like you all got knocked off, but our attorneys are still here, so we're pulling them back over.
Okay. And the good news is I had the presence to stop the clock from running when I lost connection. Okay.
Third time's the charm, right?
We hope. This will be the charm. We'll see if we can go. Just so Mr. Kimano knows, I stopped when I lost you at 7:29. Okay. That doesn't help you. It helps me with the clock. We were talking, I think Judge Stargell, the last note I have, had asked you a question regarding the series of videos leading to an ultimate question of fact for the jury to decide. And I think that was the nature of his question. I may not have rephrased it as properly as he did, but I think you were responding to that inquiry when we lost contact.
Yes, Your Honor. I just want to make sure, can everyone hear me okay? Is that okay?
Yes.
I was going to cite for the court, as I'm sure everyone is aware, what my argument would be is that without that statement, without the statement, you would have the appellant being present and no evidence of him intending that the crime be committed. And under the cases that I've read, mere knowledge that an offense is being committed and mere presence at the scene is not sufficient to establish that a person is a principal. In the case from the second DCA that I referred to in my brief was the McLean case at 754 Southern 2nd, page 176. And there's another case called Davila at 988 Southern 2nd, 35 from the Second District Court of Appeals in 2008. I would submit that with appellant's mere presence at the scene and without any indication that he intended that the crime be committed or any participation in aiding or assisting, that would be insufficient to convict him of the charges. And therefore, as it relates to ground 2 of our brief, the judgment of acquittal should have been granted. So I think it should have never gone to a jury if that was the case. I wanted to make sure that I addressed our issue number 3, which was related to ground 2, which was a judgment of acquittal should have been granted in the case. The allegation of a motor vehicle, I think I may have been on, I don't know who was on when we made this argument earlier, but just for the sake of brevity, the motor vehicle being used as an instrumentality, I think is a valid claim as it relates to the burglary. However, I would submit that there's insufficient evidence factually and legally that a motor vehicle was used as an instrumentality as it relates to the 35 counts of grand theft firearm. What I would submit is that the vehicle was used to make entry into the store so that the people that participated could go into the store and steal the firearms, but at no point was the vehicle used as they pulled the firearms off the racks and then stole them. So I would submit there's no precedent that I could find as it relates to this, but I would argue legally and factually there's insufficient evidence that the motor vehicle was used as an instrumentality as it relates to the 35 counts of grand theft firearm. And I think that that's an issue that this court may consider on the basis of the face of the record as well. Ground 4 is the final ground that we alleged in the brief. And it is where the state elicited testimony from one of the cooperating witnesses without any apparent reason or relevance as it relates to the case, that Mr. Brady, the appellant in the case, was seen with a firearm almost a week after the incident. It's clear, as I can see from the case law, that evidence of a firearm should only be admitted in a trial if it is relevant to the case. The state has to show, in order for admission of evidence of a firearm, that there's a sufficient link between the weapon and the crime alleged in the information. So there was no objection by trial counsel to this prejudicial testimony that was admitted in the trial. There was absolutely no relevance to it. There was no link between the firearm that was seen in my client's possession, according to the witness, and the crime. My client was charged with burglary of a firearm shop and stealing 35 firearms. Of course, this unfairly prejudiced him in this trial. There's no question. And there was absolutely no relevance to it at all. And then the defense attorney made no argument about it at closing, that it had nothing to do with the crime. So it was just allowed to be considered as evidence in the case and never addressed by trial counsel. So that is completely beneath what a competent trial counsel would do. It flies in the face of any case law that allows such evidence. And there's absolutely no cognizable strategy to allow the state to introduce evidence that your client was in possession of a firearm a week after he's allegedly stealing firearms. There's absolutely no reason to allow such evidence in such a case.
As I understand it, this issue was couched as an ineffective assistance of counsel for failing either to object or to close. Let's assume, for the purposes of your discussion, and I'm not asking anyone to agree, but just to concede for the purposes that prong one of Strickland has met. Count two, the second prong, would be to show prejudice, that somehow this omission rendered a verdict that we cannot rely upon. So, and since your argument is that we should do this on the face of this record, how do we address that prong?
This was a case that was presented as a severe danger to the community. It was presented in the sense that these individuals were going county to county, breaking in to pawn shops, gun shops, stealing numerous firearms, wreaking havoc on the Middle District of Florida. And to allow allow this type of evidence, that a week later, my client was casually walking around with firearms in his possession, did nothing but inflame the jury to come to the conclusion that, based on all this evidence that was allowed in this trial, the hearsay that he was involved in the planning of these burglaries and the theft of all these firearms that made it out to the street, and now he's in a housing community possessing a firearm.
Minutes now.
I think
it's up to you to go, or we can save your 5 minutes.
I'll just go into it. I don't, if that's okay.
You're fine.
All right. I think there's no other conclusion that could be gleaned that it had the effect of allowing this jury, it put the exclamation point on this fact pattern that was presented to him, that they stole firearms and that he had them at a week later and did nothing but help them put an bookend to the case, that this man participated in the crime and possessed a firearm a week later after the incident. It was the final chapter in this presentation of hearsay, inadmissible evidence that showed, according to their presentation, that he was guilty. And it was never addressed or explained by the trial counsel to come up with any other reasonable hypothesis of innocence or explanation. Thank you.
Thank you, counsel.
May it please the court, good morning.
And to stop the clock from running, or you're going to run out real fast. Thank you. You may proceed, counsel.
Donna Koch from the state of Florida. Don't worry, Your Honor, I'm going to try to be very brief in the event that we lose each other again. So, pardon me, my voice is very weak this morning. At the outset,
your volume dropped too. You were loud in the beginning where we easily heard. Now you're faint. I don't know if it's the technology or us.
Okay, we're going to look into it on our end. Can you hear me?
Yes, you're very soft.
Should I scream?
No, I don't want you to hurt your voice, your throat. No, I can hear you. I just want you to know it's soft, and I'm going to be very quiet on my end so that nothing will interfere with anyone. In fact, I'll put it on.
We're trying to rectify, but I'll speak up.
You're good there.
We need to get this underway this morning. At the outset, what I would like to say is counsel has expanded to a fault the arguments on at oral argument than he made in the initial brief. Oral argument is not a trial by fire. We don't come into this court and argue everything that we failed to argue in the briefing. That's just, it's unfair, but I just want to put that out there that a lot of arguments were made this morning that were not made in the initial brief. The second thing I'd like to say is issues 1, 3, and 4, which allege ineffective assistance of counsel on the face of the record, are not properly before this court. And that's for two main reasons. Number one, as this court's already alluded to, ineffective assistance of trial counsel is properly raised in a Rule 3.850 motion where trial counsel, if need be, is called into the court and is allowed to give any and all strategic or tactical reasons he had for the decisions he made at trial. As this court knows, it will be the rare case where ineffective assistance of counsel is going to be found on the face of the record. And those rare cases are very rarely involve evidentiary issues. Number two, the reason why this court should not look at the merits of those underlying issues in claims 1, 3, and 4 is because there was absolutely no argument in the initial brief regarding the Strickland prongs. The appellant bears the sole burden to affirmatively establish, even when you're trying to raise it on direct appeal, you must affirmatively establish deficient performance, prejudice, and in this particular case, counsel must argue and allege that there was no conceivable tactical reason for the decisions made by trial counsel. Because those arguments, and that Strickland's not even cited, because those arguments were not made in the initial brief, the very basis for reversible error in this court, ineffective assistance of counsel, was not made. Reversible error was not shown. Those issues should not be reviewed by this court for those two main reasons. I will also point out the very fact that there is any speculation about possible strategic reasons for hearsay or not just screams to the fact that, of course, a 3850 hearing is required here. There's no need for this court or anybody, especially the state, to speculate about possible, tactical reasons. That on its face right there shows that This, for issues 1, 3, and 4, absolutely, it cannot be determined on the basis of the record. Absolutely, a 3850 is required in this case. Now, I can proceed on, but given the problems we're having with technology and the fact that the law is very clear, the issues 1, 3, and 4 are not proper before this court. An evidentiary hearing is absolutely required to determine trial counsel's strategic reasons for any evidentiary hearing issues that are before this court. I will now move to the issue number 2, which argues that the trial court erred in failing to grant a judgment of acquittal on the question of the burglary and sufficiency of the evidence regarding the theft charges. The difficulty with this issue is, at the outset, it's not properly preserved for this court's review. And the reason is, and it's quoted in the answer brief, it was almost a bare bones motion for judgment of acquittal made at trial. We don't come into the appellate court and expand and massage trial counsel's arguments to be able to then come up with reviewable error in this court. We live by what was argued below. Given that, and let's put it aside, when you look at the merits of this particular issue, it's clear that Judge Sisko properly denied a motion for judgment of acquittal. And the reason is this: they conceded Mr. Brady's presence at the scene. So the only issue remaining before this court is intent. His intent to participate as a principal, or even his intent to be a participant. So intent, as we know under the law, is a jury question. It's rarely going to be decided as a matter of law. And very quickly, to go through all the evidence that this judge was considering when she denied the motion for judgment of acquittal, we start at the very beginning of this case. This was a huge prosecution. It was a 7-day trial. There were 26 witnesses. There was multiple videos. There was multiple telephone pings and mappings of where these people went, including appellate, during essentially a 3-hour criminal episode. And let's just go very quickly through the beginning of the state's case. What the state initially put on was the police detective from Osceola County. Well, what they had in Osceola County, this is where the Ford Raptor, which Judge Casanueva, I had to look it on the internet too. It's quite a large car. I was not familiar with it. This is the first part of the burglary where this very large car was driven through the back of a store in Osceola County. Well, just prior to that, what the evidence was is that these 5 or 10 young men, it was quite a few men, appellant was one of them. They were milling about in the hours before the first burglary, and they're milling about on Mercy Drive. Some of them knew each other, and you know, I'm not going to get into any questions of who said what, but this is what the evidence showed. They're all there. Well, what do? This group of men proceed to get into 5 stolen vehicles. That's the evidence. They all get into 5 stolen vehicles. And the first thing they do is they drive down the street on the way to Osceola and stop at a 7-Eleven. Well, what that 7-Eleven surveillance video shows is these young men get out of these 5 vehicles and proceed to go into 7-Eleven. The 7-Eleven video very clearly shows Mr. Brady going into this 7-Eleven. He was wearing a distinctive outfit. It was a black sort of tracksuit with red stripes down their side. This 5 stolen vehicles, and Mr. Brady was in the lead vehicle, the stolen Infinity, with the ringleader, Mr. Moore, and another gentleman, Mr. Montgomery, who was tried with Mr. Brady. They get back in, go caravan style, to the first burglary, which was in Osceola County. they ended up accidentally burglarizing a scooter store 2 doors down from the intended gun store. So all these men are right there, including appellant. They drive this ginormous car through the back of the scooter store, whereupon they immediately discover, oh, whoa, that's not the gun store. So instead of just calling it a night, they get in another caravan of 5 cars and proceed to Tampa, Florida. And on the way, and this is all cell phone evidence because they were able to get everybody's cell phone and do forensic on it and see what was happening, see what was being Googled. There is a Googling by Mr. Moore, gun stores in Tampa. So now you have a caravan of 5 cars traveling to Tampa. Well, these cars were also able to be seen in the turnpike videos as they're going through where the toll booths. So there's actually video of these cars, and they're all stolen, going through at this certain amount of time. Now, what the testimony and the evidence shows, they arrive at the Tampa gun store. It's about 2:30 in the morning by now. And there's, of course, surveillance video from the Tampa gun store. And it's able to look out on the front of on the street. And you can see, although the video is not very clear, it was much clearer for the jurors at trial. You can see this Ford Raptor being driven through the front of the store and multiple people running in. Well, what we also have commensurate with that particular evidence, video, we have the co-defendant, a co-defendant, Mr. Jackson, come into court, and he testifies extensively about this whole evening and what happened. But what Mr. Jackson says is significant in terms of participation and intent. He says that when he was in the Raptor, and when the Raptor arrived at the scene and the other cars were already there, he saw that all the people were out of the cars when he arrived. And he specifically testifies that all of these people ran into the Tampa gun store. At that point, you have participation and you have sufficient intent to at least go to a jury. Whether the jury is going to find Mr. Jackson credible at the end of the day is not a decision made in the JOA. The other fact that this court may consider in determining whether there was sufficient intent. A couple of days after the whole episode, the 3 or so hour criminal episode took place, the appellant was in jail, and Detective Cummings went to the jail to interview the appellant, pardon me. Post Miranda, the appellant tells Detective Cummings, no, I wasn't there that night. Detective Cummings testified that he didn't even ask him the time, date, or place, but appellant says to him, I wasn't there that night, I was home, and I had my cell phone with me. Well, that's consciousness of guilt. That goes towards intent. There was physical evidence showing that indeed appellant was not home that night, and appellant did have his cell phone with him. It's pinging along the route from Osceola to Tampa and then back to Orlando, which was the starting point for this whole criminal episode. There was more than sufficient evidence for this case to go to the jury. If the court believes this issue is properly preserved, Judge Sisko properly sent it to the jury. Issues 3 and 4, I'm barely going to touch on, but I will say this. They, again, are not properly before this court because deficient performance and prejudice were not affirmatively argued in the initial brief. As far as issue number 3, dealing with the instrumentality, it's clear on the face of the statute that the statute is exactly this type of scenario. That car wasn't simply used as a getaway car. It was used as a means for these 10 or so defendants, including Mr. Brady, to go inside the store. He was either guilty in this case as a principal or he was guilty as a perpetrator. I'm not going to give further argument on issue number 4. That is a strategic decision that must be fleshed out in a Rule 3.850 hearing. And the state at this point would simply ask this court to affirm appellant's convictions and sentences. Thank you for your time this morning.
Thank you, counsel, for your patience and hanging with us as well. We'll go to the rebuttal. Counsel, you have, on behalf of the appellate, 3.5 minutes remaining.
Thank you, Your Honor. With regard to arguing ineffective assistance of trial counsel on appeal, there is no case that says it cannot be done. The case law says it may be more properly addressed at a 3.850 hearing at the trial level if there is a conceivable explanation for counsel's action. As I mentioned in my initial argument, I challenged appellee to say, what is the conceivable explanation for counsel's performance, for allowing a witness to testify to hearsay testimony, hearsay evidence that their client was involved in the planning of a burglary and theft of firearms? What is the conceivable explanation of counsel's action for allowing testimony that his client was found to be in possession of a firearm a week after a burglary of a firearms store and the theft of 35 firearms? There is no conceivable explanation for it. If appellee had it their way, I would have to prove a negative here. It's their burden to show that they should at least show there should be some conceivable explanation for counsel's actions.
Well, the obvious question is going to be, counsel was never asked to give his explanation. And so we are left with a record that's silent over a week-long trial, trying to guess whether or not what a reasonable, competent lawyer would do. The Supreme Court of the United States has articulated ABA standards, all types of standards. A lot of that has not been fleshed out here. And this is not like a simple case. Well, why didn't you make a motion for judgment of acquittal on the most serious, offense? I understand. I have written some reversals. Members of our panel on our court have. But it's pretty clear cut when we do it, because it has to be clear cut. And I think the argument the state is raising is, how can we be certain that there's not a basis without the evidentiary hearing and a trial as long and as complex as this?
And I think I understand what the court is saying. In my reading of the case law is, if there is no conceivable explanation, then it's ineffective assistance of counsel. It's fundamental error. So with regard to
it's fundamental error, that is not the standard of review. The second prong is that we have to determine whether or not, under Strickland, he suffered prejudice within the meaning of the Sixth Amendment, that we have a trial whose result we cannot rely upon. Fundamental error would have happened on direct appeal, when we would have concluded, had one of the issues been, was it error to let the testimony in, and we would have said yes, but is it fundamental? I'm not sure we'd get there on this case. It goes down to the heart of the trial. So it's two different standards of review, I guess, is the point I'm trying to make simply. I don't want to use up all your time.
Yes, sir. No, I appreciate that. I mean, I'm here doing oral argument on behalf of my client, but also I try to, get better every day. So this is helping us
we all
do better for my clients. With respect to that, I would submit, as I have before, there's no conceivable explanation for allowing the evidence that was presented, especially when it's the only evidence that the defendant was involved in the crime. And if we really look at the record, there was no attempt to explain it, explain why he was in possession of a firearm, to explain what we meant. And again, I would submit that appellee is doing what we predicted they would, in arguing that it's okay for this court to conclude that one witness, when he says everyone got out of the car, is not ambiguous, that it was specific to my client.
Your time has indeed expired. And I thank you both for your presentation today.